Let's take you to the High Court sitting in Pretoria, where the court has ruled inadmissible the audio recording of the alleged confession made by accused number 2, Bongani Ntanzi. Ntanzi's legal representative, argued that the recordings were made without his consent. Judge Ratha Mokgoatlheng says the constitutional rights of the accused would be infringed upon if the tapes are used as evidence. We speak more about the trial with Mpumelelo Zikalala. He's a legal analyst. Mpumelelo Zikalala, thank you very much, sir, for your time this afternoon. Let's revisit the moment when the judgment was handed down.
If this court allowed such an egregious flouting and flagrant flouting of accused number 2's constitutional rights in terms of section 35(5), it would not be in the interest of justice to do so, because accused number 2 would then be continuously subjected to a trial unfairly, when we know that the Constitution engages us and enjoins us to prevent such an exigency. And also, in the view of this court, that would bring the administration of justice into disrepute. Consequently, this court rules that the audio recording should not form part of these proceedings. It is inadmissible.
Mpumelelo Zikalala, is this a precedent-setting judgment, as we heard yesterday from the judge saying there was no case law to cite to guide him in making his decision?
I would say it is, and one which has been crafted by, I would say, a very experienced judge, and which is certainly going to allay a few fears that us as legal practitioners might have had. I think it's answering two very pertinent questions. If we look what the Constitution says under Section 35, it's anything which is, any evidence which is going to be produced to violate your right at the end of the day, it mustn't be included in this case. And this one, you are looking specifically at the right to privacy. You must be informed that these are the things which are going to happen. You are being recorded at the end of the day, so that you take an informed decision of whether to continue speaking or not. And another important thing that I think the judge might have looked at is, when you say a person has been informed of their right, do they fully understand the consequences which are going to follow if they choose to do a confession, or is it simply just a tick box exercise? So, the informed consent requirement does not only extend to you being told verbally that this was going to happen, it goes further in your understanding is what exactly do you understand if you are saying, yes, I'm going to agree to this particular course of action, despite the warning that you would have received from the presiding officer.
Let's get into the cross-examination of the witness currently on the stand in the trial. Let's take a look, listen at this.
If that confession in terms of section 2171A is made by an officer but not in the presence of a magistrate, do you regard that as a properly taken confession?
Sover ek verstaan, as daar enige bekentenis gemaak word aan byvoorbeeld 'n polisie of 'n persoon wat nie die rang van offisier dra nie, met ander woorde is 'n laer rang.
As far as I know, as far as I understand, if a confession is made to a person who is not an officer or a person who is lower with regards to a rank, ngokwami ke ukwazi uma ngaba ke i-confession leyo yenziwa ke futhi yenziwa kumuntu ke ongasiyona ke i-officer noma ke ngesikhundla ke unesikhundla esiphansi noma esisenzansi,
dan moet daardie bekentenis voor 'n landdros.
Mpumelelo Zikalala, can a confession statement be made in front of a magistrate, or should it be made to a police officer?
It can be made in front of both, but when it comes to the peace officer, the magistrate needs to confirm it at the end of the day to say, are you giving the statement freely and voluntarily? Is there any undue influence that's been provided to you, or are there any threats that would have taken place? Now, the safeguard of that is to say, then the magistrate goes a step further in terms of asking those interrogating questions. Is it within the language in which you understand you draft this particular statement? Are you well conversed if it's written in English and you speak in a vernacular language? Do you really understand what you are doing in these particular consequences? And also the consequences or which are going to follow based on the content of that particular statement. Now, a clear example of this would be to say, if you are admitting to murdering someone and the minimum sentence which you are going to receive is a life sentence, that type of explanation must then be made to you as an accused to say, do you clearly understand what you are getting yourself into? Or would you rather have a legal practitioner who understands what Section 217 of the Criminal Procedure Act actually states, who understands what Section 35 of the Constitution actually states, to be by your side to make sure that the confession in which you are going to make is one which can be able to suffice any court proceedings where it's going to be subjected to. And I think it's also a sit from the side of the state to say, instead of trying to short-circuit these type of things and trying to ensure that you come back with a conviction, insist of a legal practitioner being there so that once a conviction has been made, either to a peace officer or to a magistrate, you are going to have a clear stance and a clear defense in terms of saying, we've done everything that we could in a manner in which complies with Section 217 of the Criminal Procedure Act to make sure that the substance and the content of the confession can be utilized.
In fact, Advocate Mngomezulu saying that he received instruction from his client that he was not represented by a certain Mr. Mjiako, whose name has been doing the rounds in the court. He was not represented, and he does not know Mr. Mjiako, something that the witness took exception to, saying that, well, he is lying. And then he's also gone into Advocate Mngomezulu on whether the form that was used to capture, or rather to explain the rights also to the accused, whether it was a statutory form, this pro forma, or it was a guideline, saying that he wants to establish whether extrinsic evidence was complied with. From what we've heard so far in the cross-examination by Advocate Mngomezulu, was extrinsic evidence complied with?
I would say no, but maybe in re-examination there may be certain things that might be clarified. In this instance, as stated earlier, as a magistrate, you must then want to make sure and understand that does the person know and understand the consequences of what they are doing, let alone the content of the affidavit which is going to be in front of you. Do you know the type of consequences which are going to follow from you or to you as the person that is making that particular confession? Secondly, let me make sure that there's no undue influence that is there. Now, if you come in with an investigating officer that has allegedly hit you behind the scenes and that's not been told to the magistrate, you are still going to apply that fear, and you're not going to be able to answer freely because you know what's going to happen to you once you are outside the office of the magistrate. So at the end of the day, it's the testing of the information and also of the confession to then say, can it be utilized and be able to stand be cross-examined in a court of law? The only way to do it is to check, are you doing this confession freely and voluntarily? No undue influence has been offered to you. Let me remove all the other individuals that are there so that I'm able to make sure that I'm getting the perfect or the correct information from you. You are not simply answering and saying yes because you fear that once you are out of that office, there's a number of undue influence or assaults which you are going to suffer.
Okay. Thank you very much for helping us make sense of today's proceedings. Mpumelelo Zikalala is a legal analyst.